off. We'll start with the pledge to the flag. Please stand. Place your right hand over your heart. Repeat with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Out of default, I'm just kind of starting this meeting off because the first order of business will be the swearing in of the Planning Commission by City Clerk. Are we doing VAR also? Did I see some VAR out here? No, we're just doing the Planning Commission. So we're swearing in a Planning Commission, and then we'll select a chairman and vice chairman, and we'll start the meeting.
So if I could have Mr. Brents, Mr. Cuff, and Mr. Rodriguez. Yeah. So when I say I, you will say your name after that. If you could raise your right hand and repeat after me. I do solemnly affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. If I could get your signature. Justin, this one is yours at the bottom. Thank you.
Thank you. Excuse me.
At the bottom. And one more, David.
Thank you.
Thank you.
All right, thank you, Lisa. Okay, having got that done, swearing of them, we will select the Planning Commission chair and vice chair. We need one of each. I'll nominate Jack Williams if he would like to be chairman.
Yes, thank you.
Do we have a second to nominate Jack?
Second.
Any discussion? See no discussion. Vote. All in favor say aye. Aye. All opposed? Passes. Jack is the chairman. And now we'll pick a vice chair.
So we start with musical chairs. Okay, so the next order of business is selection of a vice chair. Do we have any nominations for a vice chair?
Well, I don't know if one of the new folks would like to do it. It's you only fill in if Jack isn't here, and it's a good way to train. It makes you keep on your toes. I've been chair and vice chair years, so I don't need to do it, and we're obviously all capable. So if somebody wanted to, I'd sure nominate them.
I could do it if you guys, or do you guys prefer?
It's fine. If you like to volunteer,
I'll nominate Justin Rodriguez as vice chair.
I'll second.
Second. All in favor?
Aye.
Aye. Welcome to the board. Okay, moving on. Public comment. Requests from the public to speak to the commission on matters not on the agenda. Does anybody want to speak? Seeing none, we'll move on. Are there requests for continuance, withdrawals, or addition of ex-agenda items? None again. How about conflicts and ex parte communications? No?
and I can do it now or do it later. I suppose I should do it now. I mean, Bent Peterson, I know what he's doing on his property only because over the few months he's discussed it with me, but I haven't made any statements. I've just listened and directed him to staff for information.
Okay, anybody else? Okay, approval of the minutes from the February 4th meeting. I'm not sure how we do that since we only have two people here who were at that meeting.
Is that a quorum?
Happily, there is no legal requirement that you have been present at the meeting to approve minutes. Certain due process items do have a rule that he who decides must hear, but it doesn't apply to minutes. Now, I'll tell you that nobody's ever listened to me on that. I've been doing this for about 35 years now. But you have to have at least 3 people to take action, and there's nothing bad that can happen if people vote on approving the minutes even though they didn't attend the meeting.
Okay. Well, I'll move approval of the minutes from the February, what was the date? I'm sorry, 4th?
4th? Since I was there, I'll second. All those in favor?
Aye.
Aye. Anybody? Okay, Brown Act training for planning commissioners and Board of Architectural Review members. I see we have most of the BAR here, all of them, I hope. Yeah.
That looks much better. Okay, I'm going to kind of tend to direct most of my comments to the Planning Commission chair, but I find that these things always go much better if people from everywhere interrupt with questions if they have them, because droning on isn't really effective communication anyway. So I have slides. I'll be happy to blast through all of the ones that regard the Brown Act. I'm going to show you a couple of slides that have to do with the conflict rules and the due process rules, but we're not going to go through all of those. But just a couple of brief comments for things for especially new members to think about. Basically, I didn't do a whole bunch of extra work to bill you guys for. I stole this presentation that Mr. Fleischman has put together that covers all of those things. And even as just relates to the Brown Act, all of these policy considerations apply. It's not just effective governance. It's not just making sure that the public has confidence, but it's always good to avoid criminal and civil penalties and avoid having your decisions set aside for failure to comply with the Brown Act. The biggest things to concern yourself about from the Brown Act perspective for you really is the serial meeting rules. The technical Brown Act rules about what the agenda has to look like, where it has to be posted, how things are supposed to be described. Your staff's all responsible for that. And if that's not done correctly, at some point in time, we might have to say, I'm sorry, we're going to have to postpone because we didn't quite do this particular thing right. But it's not your responsibility in between meetings, and it's not your responsibility to review all that before meetings. We might touch on that a little bit about it. I will talk about the 500-foot rule-ish, even though that's relates to conflicts. It's been newly changed. It happens from time to time, and so we might as well mention it. This is the preamble to the Brown Act, and that's why the legislature passed it. Unlike some other acts, it wasn't done by initiative. This was done by the state legislature, and they do amend it from time to time. And it's basically to remind us all that it's self-governance here. We're doing our business as people, but it's the people's business. And it's representative self-governance, not like the old days in ancient Greece. It's your meeting, not the public's meeting, but we do it all in public except for certain exceptions. And I've never had a planning commission meeting in closed session. Theoretically, it could happen in some situations where if you were all named, if the planning commission was named as a defendant in a lawsuit, we could meet in closed session to discuss that. But all the other types of rules that allow closed session meetings do not generally apply to Planning Commission. Entities subject to the Brown Act, and obviously I'm talking to you about it, includes the Planning Commission. It does include some private corporations. The law says publicly funded, those are the English words, publicly created or funded. Just because you get some money from the city doesn't mean a private corporation is a Brown Act body. We got a nice clear example here, which is the SCVB. If you go back through the history of the SCVB, even though that's technically also a private nonprofit corporation, it was created by council participation and council action way back when. That's the key point why the SCVB has to follow the Brown Act. It's because the city as such participated enough that it makes it a Brown Act body. It's not just the fact that they get a large sum of money. Conversely, now your Chamber of Commerce gets what is a large sum of money to a lot of people, even though it isn't big compared to the SCVB money. That sum of money doesn't make them a Brown Act body. City had nothing to do with the creation of the Chamber of Commerce. Likewise, the nonprofits that come and apply to the City Council every year, those don't become Brown Act bodies just because they get a grant. Successful candidates, certainly to the City Council, even before you're sworn in, after the election certified, you're covered. We take the position that as soon as you were informed that you were appointed to the Planning Commission and before you were sworn in, it was safe to assume that you were covered by the Brown Act. Nothing came up. So the purposes are to give public access to decision-making so they can have oversight of it, but we also can protect certain privacy concerns. What's a meeting? So a meeting is any time a majority of the members of the body are present at the same time and place to hear, discuss, or deliberate items that are subject to jurisdiction of the body. So all 5 of you can be at a social function, and if you're not discussing anything that is subject to your jurisdiction, that's not a meeting, though, even though you're all 5 in the same room. All these same rules apply to the Board of Architectural Review. Now, a lot of people tell you to avoid that because it's hard to prove a negative. In other words, if someone sees you all 5 having coffee or all 5 going out to dinner, they may assume you're discussing things that you aren't, and it's very difficult to prove that you were not discussing Planning Commission business if you're all 5 together. But technically, you can all 5 engage in social activities without worrying about that becoming a meeting. It's only a meeting if you're going to see, hear, or discuss. So even though you don't discuss, if you are getting information as far as things you have jurisdiction to, that could be a Brown Act meeting. It constitutes deliberation. Serial meeting is the next big thing that you really have to worry about, and that is because you can have a meeting accidentally, or sometimes people will do it on purpose without following the rules, without any of you being present in the same room or talking on the same phone conversation with any other member. Because a serial meeting can happen between 5 Planning Commission members if a member of the public discusses Planning Commission item with one member and then takes what Planning Commission member number 1 said about it to Planning Commission members 2, 3, and as soon as we have the 3rd, we have conversation being delivered between 3, which in this case is a quorum. That's a majority of the members of the body. So you got to be careful even when you're talking to members of the public. If they want to share with you what another Planning Commissioner member may have said about it, that could end up putting you in a spot where you violated the Brown Act. The member of the public hasn't. They're not subject to the Brown Act. They have free speech rights. They get to lobby you on everything, for or against. But if they start talking about what another Planning Commission member thinks or has said about something, even if they're not talking about voting commitments, because it's not just votes, it's deliberations that have to take place at duly noticed meetings. So serial meetings can take place through any number of types of communications. We've got they basically can, no matter how you do it, whether it's by phone or person or email, and lots of other methods nowadays. It can either be with one person as the hub who speaks to everybody, or in this case, it's called the daisy chain, where the message just goes from planning commissioner number 1 to number 2 to number 3 to number 4, even though no more than 2 planning commissioners ever discussed anything at one point in time. It can get a little complicated because it's perfectly legal for 2 planning commission members to get together without noticing a meeting. They don't have to tell anybody about it. They don't have to let the public attend, and they can have a private conversation about anything that's subject to the jurisdiction of the planning commission. If it doesn't go any farther than that, it's perfectly legal. And you can do it regularly or sometimes, but if it turns into that third member receiving part of that communication so that you're effectively taking deliberations or part of the deliberations outside the meeting, then we've had an illegal meeting, and those end up with bad consequences. So that's distinguished between the serial meeting and individual contacts, which I've already talked about. They can be either between planning commissioners or members of the public, or council members or staff members. Staff's slightly different because we have a great rule for staff. We can serially give you information one way. Doesn't have to be part of the Brown Act. So that helps staff make sure you all have the same information. It wouldn't be fair for planning commissioners if 2 of them got more information than the other 3. And not all your information is going to be in an agenda packet all the time. So we, as staff members, can serially one-way communicate with you and give you information. Quite often, if we do it by email, we'll try and remember to blind copy at least 4 of you, so that if you accidentally hit reply all to make a comment, it doesn't go to the other members, because you can have a serial meeting by email. So be careful if you get an email from staff and it's been copied to all the other planning commission members. If you ask a deliberative question and it gets circulated by email, you've got a technical violation of the Brown Act. I haven't seen that yet lead to any problems with the DA or lawsuits, because an accidental violation isn't likely to lead to any of those serious activities. If a district attorney looked at something after somebody complained and figured out that this was just an accidental, the person hit reply all, didn't really intend to have deliberations going on, nothing's going to happen. But technically it's a violation. And if it ever is pointed out to us by a member of the public that we've had these accidental technical violations, the best procedure is to lay on your sword and say, yep, I did it, and I'm not going to do it again. Cities who have tried to be defensive about it end up with litigation that they lose, because the court says, well, because you weren't completely honest about your accidental violation, I'm not convinced we didn't need this lawsuit to prevent you from further violations in the future, so you lose. So I've been doing this for 35 years. I've only had to once say out loud, yep, collectively, we fouled up this time. Here's how we fouled up. No one's going to do it again. So it doesn't happen often, but that's the response when you do.
Roy?
Yes.
As a rule of thumb then, when we get an email from staff that goes to everybody, we should do one of 2 things if we have questions. That is, go talk with staff directly, or just reply directly and not reply to all in
Yes.
an email.
It's just, that's
would
true.
be- that
I
would
highly
cover us.
recommend that. And the problem is that we send so many emails in today's world, we sometimes click reply all without thinking about it. I did that on not in a city business chat, but in a city attorney's chat once, where someone was complaining to me about what they thought was unethical behavior by another attorney, and I intended to reply just to the person, but included in that reply was a chat room. Now, I got really lucky, because that chat room had a moderator at the time whose personal phone number I knew, and my brain panicked immediately after the finger hit send, because that was when I realized what I'd done. So I could call and intercept, but most email nowadays, once you've clicked it, it's gone. You're not getting it back. And so, yeah, I always tell people don't hit reply all, and then like everybody else, sometimes I hit reply all when I shouldn't have, or even when I didn't mean to. Social media can be an example of a serial meeting. The one from Rex Richardson says, "Hey, Susie," over here. That's suggesting an action. So if that's social media and that goes to all members of the planning commission and you posted it, that's deliberations. If naming the library was subject to your jurisdiction, that person just made a suggestion offline about what that board ought to do. And I'm sure it was totally innocent. And the law hasn't caught up to this yet. But right now, if you technically read the law, even though many of these social media outlets are totally open to the public, the Brown Act, as written, does not recognize that as being in open session. It's still a private communication as far as the technical reading of the Brown Act goes. I doubt if they change the Brown Act that they're going to make that okay anyway. So be very careful about social media commentary. It could accidentally end up. So we always tell you to avoid discussing the planning commission business, in this case with more than one other board member outside of a public meeting. Again, that's just good advice. That's not technically required. I like to be honest about what the Brown Act says. So actually, Mr. Peterson, Mr. Rodriguez could have a discussion in private about something. Mr. Rodriguez and Mr. Williams could then have a discussion about the same topic. As long as Mr. Rodriguez didn't share anything about what Mr. Peterson said or thought, we haven't had a serial meeting. We still recommend against doing that because it's not really safe. Again, it's almost impossible to prove a negative. Technically, you swearing under oath that you didn't share what Mr. Peterson said with Mr. Williams, if believed, is proof, but all someone has to do is disbelieve you, and we failed in proof. I'm sorry for picking on you. I don't even know you, but you were in my line of sight. And so the other thing to do is when you're talking with if you're talking with a member of the public or any other planning commission member, remember, don't ask what any other member of the planning commission thinks or says about it. In your private business, it's perfectly legal. If you're a member of a board of directors of a private corporation, even most private nonprofits, you can all call each other and discuss everything ahead of time. You can share information amongst yourselves, and it really helps you be efficient. But the Brown Act doesn't allow you to be efficient. So you've got to follow it even though it gets in the way of efficiency, because it sets a higher priority on openness and doing everything in public as opposed to being efficient. So there are lots of things that aren't meetings that you have to worry about. I already mentioned social ceremonial events. So ceremonial would be in someone gets an award, they're putting in a plaque outside City Hall, we're raising the flag on Veterans Day, those types of things. All 5 of you can show up. You don't want to huddle in the corner and then have a secret meeting, but if you all 5 show up, it's perfectly okay because it's a ceremonial event. The individual contacts, we've gone over. Conferences. Some of you may be going to a league conference on planning commission training. That's perfectly legal. You can attend that conference, and you can even, 3 of you attend the same subsection meeting of it if you want to. Often you split up to make sure you get things covered, but you can all go around at the same time. Now, you can't take advantage of being out of town and having a secret, non-agendized meeting about actual planning commission decisions, but you can attend and fully participate in the conference, and you're not violating. You can also attend other meetings of other Brown Act bodies without it being your own Brown Act meeting. I recommend again that if 3 or more of you show up at a planning commission meeting or a BAR meeting or somebody else's meeting, that you don't all sit together, but there's no law that says you don't have to. Again, that's just to prevent somebody from assuming that you're having a conversation that you're not having. So if we have a quorum of the BAR here tonight, that's perfectly legal, because this is a duly noticed meeting, and so they can all attend and they don't have to notice their own meeting. Sometimes we do have joint meetings of, more commonly it would be City Council and Planning Commission, but that would be when they're both expected to take some form of action. Because when you show up and you just happen to be a quorum or more attending the City Council meeting, you aren't there to take action, you aren't there to participate as a Planning Commission, you just happen to all be there. Oh, actually, let's see if I can go back. Yay. I forgot to cover community meetings. So if someone else that's not a public agency schedules a community meeting on something and it gets publicity, that's the legal word, is publicity, and you happen to have a quorum or more show up, that's legal as long as enough publicity has taken place and within the confines of the fire limitations on how many people can attend, the public generally can be there because it was publicized. Now, none of us know what publicity means. This was written a bazillion years ago. Back then, we would say, well, if it was in the newspaper, you'd be safe. So if it hasn't been in the newspaper, then it probably hasn't been publicized. Well, we know that's no longer true, because who publicizes in newspaper? I hope we don't have a newspaper owner here. But who publicizes in newspapers anymore? But the law hasn't changed, and we have community meetings all the time. So really the only thing we can honestly say from my lawyerly perspective, besides we don't know till someone gets sued and loses, is anything that looks like it got widespread publicity, like kind of a newspaper did a bazillion years ago, is going to be good enough. If it's social media, if it's banners plastered all over town, or people posted flyers on illegally on every power pole and light pole around, if it's the word's gotten out sufficiently that a reasonable number of subsection of the community is bound to know about it, you're safe. That's publicity. So, and you can always check. You can always find out how much has been done and check with us ahead of time. So I'm going to just blast through meeting agendas because this is not your bailiwick. So we have to make sure that there's a general description. It's brief. It can be 20 words or less, and all the safe harbor descriptions are very short. That describes actions to be discussed and actions to be taken, such that a reasonable person out there can look at the agenda and know whether or not they want to attend. So you don't have to, we don't have to describe there's going to be 6 different sub-actions on this item if we can otherwise describe it in general so that a reasonable person knows what's going on and knows enough to attend so they can yell at you if they don't like what they think you're going to do. I mean, that's really the Brown Act test there. There's different timing requirements for different kinds of meetings because you have your regular meetings at 72 hours. Special meetings are 24 hours notice. Special meetings, there's no limit how often you can have them. There's no rule that says you can't have a special meeting on the same day you have your regular meeting. You could have a special meeting at 5 o'clock and start your regular meeting at 6 o'clock, and we could give notice of the special meeting only 24 hours ahead of time. Those things don't happen that often around here, but those are technically legal. So we have to remember to post them, and we have to remember to, I would use a different word here on the slide. We say no action or discussion on the subject if it's not in the agenda. I would say no action or deliberation, because you can't have discussion. For instance, if somebody brings up in public comment about something they think you should have on a future agenda, you can talk about whether or not you think it should be on a future agenda. And you can actually vote on whether or not to have it on the future agenda. You can also briefly talk about anything that's subject to the jurisdiction of the body, just because it came to your mind. Brief, again, is one of those nice legal words. I can tell you the code says briefly. I can't tell you what briefly means. Never been litigated, so I don't know what brief means. Now, Dave Fleischman, who's now your city attorney, we switched a couple years ago, I think came up with the best definition of briefly, which is the public's allowed to talk briefly. So if you don't talk any longer than we allow an individual member of the public to talk, that's brief. That's the best definition I can think of. So if we got a 5-minute limit on the public talking and we consider that brief, then if you stay 5 minutes or less. Now, if it's not on the agenda, you can't deliberate about it. So other than whether or not you want to have it on a future agenda, don't discuss the merits of it amongst yourselves. But if one of you is really impassioned about something and then you just need to report on it for up to 5 minutes, you're going to be okay.
Can't you say, like, it's a good idea, we should put this later? Is that
Yes.
brief? And
Oh, yeah.
then you move on, right?
Oh, yeah. I'm not discouraging real brevity. I'm just telling you that I can't tell you, legally speaking, that you have 1 minute, 2 minutes, 3 minutes, 4 minutes, or 5 minutes, because we don't know. No one's got sued over it and lost yet. The key is not to take action other than deciding whether or not you want it on a future agenda.
I have a question about
Sure,
that.
please.
If that's happening in a public meeting, how is that violating the Brown Act?
Because the public has to have notice of what's going to be
Oh, okay, got it.
taken action of. So if it wasn't on the agenda, there's somebody at home didn't know to show up. See, I knew the answer on that one. So, at the meeting, members of the public must be given an opportunity to address on any topic subject to your jurisdiction. That was the community forum at the beginning that no one chose to speak at. Technically, the rule says it has to be subject to your jurisdiction. So if somebody wanted to discuss something they thought that the county was doing that was not proper, you don't have any jurisdiction over the county. Now, if you've got a 5-minute limit for them speaking, you have to balance when you're running the meeting as the chair. Do I let them go on for 5 minutes about something I don't have jurisdiction over, or do I fight with them for 10 minutes trying to explain that I can forbid them from talking about it because it's not part of our jurisdiction? And I tend to fall on the, go ahead and tell them it's not really your jurisdiction, but let's not use the gavel because it usually ends up taking longer to fight over the issue, even when we're right, than it is just to say thank you at the end of their 5 minutes or 3 minutes and move on. But legally, you don't have to allow comment on that. You have to allow comment before or during, I don't know why we say that in the code, taking action on an item. So before you take action, you have to allow comment. There's no law that says you have to call for it, oddly. It's better practice to call for it, but you have to allow it before you take your vote. I was city attorney in King City for about 12 years. They never asked for formally public comment. The culture there was, and everybody who attended meetings knew this, you were expected to, when your item was coming up, if you wanted to talk, go stand at the podium. That's how you told the mayor who was running the meeting that you wanted to make comment. And yeah, if somebody waited 3 or 4 seconds too long, oh, wait a minute, yeah, they always let them come up, but they expected people to let them know that they wanted comment. Other than that, they just went right on with their business, and that's perfectly legal.
Question for you. It seems to me, and I can't recall, I mean, we're going to be doing it tonight, but we start off with staff giving a report, questions of staff. Then applicant gives a report, questions of applicant. Then public comment. Then we discuss. Before we vote, we bring public comment back in.
No, you're not required to.
But we can. I mean, it's
Can.
just hard for the public. They don't know how we're discussing
Right.
stuff. So now they're putting their hand up and we want to speak. We've always been pretty generous, at least at our level and BAR, to do that, it seems.
The whole city of Solvang in my 20 years here has always been very generous in that regard.
Even city council.
More
Okay.
generous than any place else I've ever worked.
Okay.
That's just the way it is. That's just the culture here. But it's not required.
Just the
So
one time.
just the one time is all that's legally required. I went to junior high, high school, and college in Berkeley, the Athens of the West and the capital of free speech. At the city council, they may have changed this, but the last time I checked, at the city council meetings in Berkeley, the capital of free speech in America, they had all their public comment at the beginning of the meeting. So we are going to set aside X amount of time for public comment. Here's all the items on for action. You've got 3 minutes. Whichever ones you want to talk about, here's your 3 minutes. And everybody gets up and they have to give their public comment before they ever get to any of the items individually. And that withstood a challenge. So that was technically legal according to the Brown Act because the people were given the opportunity to comment before they took action. Now, I'm not telling you to do that.
It seems like if you do that, you're going to get the public giving you earfuls on the Monday before the meeting and the Tuesday and the Friday and lobbying you instead of, I always tell them, just come here and talk. I don't want to
Right.
talk, just come here. Which if we give them the chance, you avoid a lot of that problems.
I think the problem in Berkeley is if when they didn't have limits, then the meetings went till 4 in the morning before they could get to the action.
I gotcha.
So that was part of their motivation. But here, that's not the culture of your public. And the culture of how you've run your meetings has never been that technical. But legally, you can be very technical on it. The law sets the minimum standard for your behavior, not the maximum. So just because the law says you can cut off public comment doesn't mean you have to. The only thing you have to do is be fair in a due process sense. So if you're going to let people for a project speak longer or again, you've got to make sure that people who have the opposite opinion are given the same opportunity. Because then you've been fair to everybody. It's been content neutral as far as allowing more comment than the minimum required. And as long as you do that, you're good. Okay, this is the only entertainment part of the evening, if it actually works.
Help from above, and with the flying saucers, they do above.
On the East Coast, they have
So,
slaves, and they
so not necessarily subject to the jurisdiction of the body.
we don't believe in that. We believe in the union, and that's what we are.
But listen, honey, I know that you've got Pilates going on, but I've got to go to my traffic.
These are actual public comment at other meetings, not here. And you can see the chairs of all these meetings are basically just figuring, I'm better off waiting till the time is up.
Really good. He has government funding for small business owners. I'm just tired of being a second-class citizen and being relegated to a ghetto.
No, if I had to sit there, I would be ashamed
This is for the Planning Commission staff.
department, which I would call a Gestapo, the KGB wannabe. You know, I would fire these guys.
Except for the people that were talking about things that weren't subject to the jurisdiction of the bodies they were in front of, like flying saucers, and that's all legal. The test for the chair on public participation really is, are they disrupting the meeting? So don't think about the content of what they're saying, because rarely can content be legally disruptive. It is behavior disrupting the meeting. It's the Planning Commission's business meeting. Public has the right to attend. Public has certain rights to make comment, but it's still your business meeting. It's not a town hall meeting where everybody has a vote. It's your meeting. And so you don't have to allow it to be disruptive. Been here over 20 years. We've only had one time where someone was disrupting the meeting. And we had a fire department then, and the fire chief, it was kind of funny to me now. The fire chief, the podium was over here by the door, and the fire chief went to approach him, and the guy kept backing up. And so the fire chief just hit the door, and out they went. Out the door, and you can't get back in that door. And then the guy calmed down. By the time he could make his way back around, he'd realized that he was being a jackass and calmed down, and we were okay. So, closed sessions, you don't really have to worry about that. I'm going to blast through slides now. Yeah. Violations of the Brown Act can be criminal. I've never seen anybody go to jail for it, but technically it could happen. And they can be civil, and that involves money. It could be money out of your pocket, the city's pocket, and we could have decisions invalidated for violations. Your staff has this slide, so if you want, I mean, the whole presentation on them. So if you want to get the references, you can get those. I'm just going to very briefly touch on, because I can briefly discuss something now, conflicts. God, I'm going back to Berkeley again. There's a ex-city attorney in Berkeley who, her line about conflicts was, don't worry about having conflict. It's not a social disease. Everybody has them from time to time. I don't know why we call them, like, I know we're supposed to avoid conflicts of interest, but we say we have them. And I kind of don't like that, because what you do when you state your reason for not participating, for abstaining, is you're avoiding behaving in conflict of interest. But no one else in the state of California agrees with me on discussing it this way, so it's just me. But I really think what you do when you recognize that the FPPC rules are very strict and you follow them is you're avoiding conflict of interest. You're just behaving in the public interest. Yes.
With respect to conflict of interest, when does a person say, I have a conflict of interest? When do I need to leave the dais or leave the room? And
I think the best way to do that, technically according to the code, would be right after the item is called. And you say, I will be leaving the podium or the room, depending on the circumstances. You state that you have a conflict of interest, but you identify it as well. I have a property interest, I have a business interest, I have a personal interest, whatever the conflict is. If it's your personal residence, you don't have to give out your address, but you do state, I have an interest in real property that creates a conflict and I can't vote on this one. Lots of times you have to leave the room. Sometimes you can stay in the room. If you want to stay in the room, ask me. It's always safe to leave the room while the matter's being heard. Sometimes it's legal to stay in the room. For instance, if it's your personal residence that creates the conflict and it's only owned by you or you and your spouse, you can stay in the room and you can make comment like any other member of the public. Most other types of conflicts, you have to leave the room. Because if you have other owners, that person can show up and be in the audience when the item is being deliberated, and they can make comment. But the law does allow you, when it's just solely your personal interest involved, like any other member of the public, you can comment on it.
So, Roy, just real quick.
Sure.
We should change our agenda maybe. When I look down at A, B, C, D, E, where it says conflict, it should be in front right on 2A, should have a conflict, and then 2B, so that at each of them we give the conflict. Is that cleaner, better?
I like that better because I think it more comports with the way they wrote the code.
That
in
it's supposed to be on
Political
that
Reform
item.
Act. Yeah.
Yeah, okay.
That presupposes that knowledge, however,
Yeah.
and that you can know your addresses and you've checked your maps, or that,
Yeah.
or it depends on staff then to inform.
Well, the conflict doesn't have to be noted on the agenda.
Okay, right.
So it doesn't have to be pre-printed ahead of time. And it's a nice reminder. Yeah, to think about it. Now, we're not doing AB 1, 2, 3, 4 training tonight. That's the good news, because I would drone on for 2 hours. It's minimum required 2 hours. Everybody has to do it within their first year of being appointed and every 2 years thereafter. It's free, available online. And the online AB 1234 training it counts just as much as getting it in person. So, if you haven't filed your assuming office statements yet, do so, because you got to do so within 30 days. That's the other training you're going to get. This is the other slide I wanted to get to. These are people who forgot to file their statements. Now, this one guy on the top person, Allison, she did fail for 4 years, and she got fined $12,000 for not filing her statements. There's no finding in there that she ever participated in the decision when she shouldn't have. It's just she didn't file this form that we got to file every year. And I understand I got to fill out that form, and it's a pain in the neck to fill out the form, and it doesn't make sense. And they make me say I have to check a box every year. What's the value of your business, which is Hanley and Fleischman? And the honest answer is 0, because nobody in their right mind is going to pay a penny to buy Hanley and Fleischman. You can't buy Solvang as a client. And we're at will. We could be fired without notice at any time. It's been that way for 20 years, so I don't think it's going to happen soon. But there's nothing to sell. But I have to check a box. So the first time I filled it out, I checked the box, and I checked the smallest box. And I got a call from the FPPC. They said, that can't be true. I told them the only part that's true is that it really has no value. You can't sell it. You can't sell legal practice anymore, really. You can sell your building, and if you think your chairs and books and things like that have value, you can sell them. But even books nowadays, that's on the library. But yeah, so they make us fill out these forms, and it's really a pain, but we got to do it. And if you don't, you get fined. There's this one person who was just late, the annual statement, and they got fined $200 just for being late because somebody complained about it. So get them done on time. I've handed out to everybody my little chart, if you don't have it already, on the 4-way test. They change the rules all the time. It used to be an 8-step test. I said 4-way. I used to be in Rotary. It's a 4-step test. But that's the new rule. Now, if there's a decision and you have a real property interest within 500 feet, the law assumes, and Aaron's going to know this distinction. It used to be it presumed. Now it assumes you have a conflict of interest unless you can prove by clear and convincing evidence that you don't. And this is a new rule. And assuming is much different than presuming, because when we used to just presume, you could have reasonable evidence to rebut that presumption and you could go ahead and vote. Now the law has changed. The law assumes that you have a conflict, and unless you come forth with clear and convincing evidence, which is almost like beyond a reasonable doubt in a criminal trial, but it's flipped. So if I would just interpret that if I was a planning commission member, or if I had any sources of a conflict in town, I would just interpret that 500-foot rule as hard and fast. If I have a property interest within 500 feet of the property that's involved in the decision, I'm just declaring a conflict, because I don't want to be the first person that tries to think I've got clear and convincing evidence and have that fly. Between 500 and 1,000 feet, there's this new rule. If it's any of the things listed, we're back to that presumption. I'm not fond of trying to overcome presumptions from a conflict situation either, but people have. So if there's any of these types of activities and you have a property interest that's within 500 feet to 1,000 feet, here in Solvang, this is going to come up because it's a small town. And although they write these rules for the council members in Los Angeles and San Francisco, the same exact distance rules apply here. So it's going to come up more often where one or more of you are in that 500, 1,000 foot area think about it very carefully before you participate.
I have a question about that.
Yeah.
Does like staff give you a bubble, or will they like drop a pin
Yes.
on Google and say, hey, like the
Staff will
picture?
be doing that. You give staff the information of any property interest that you have. Property interests can include certain types of leaseholds too, or beneficial interests in trusts. Things there's not real. They got pretty clever about it, thinking about all the sneaky ways people use to get around having their property ownership public, and whichever one you might use, if it's the duck test, if what you really have is an ownership interest in property that's worth more than $2,000, it's a property interest whether you're on a deed or not.
Question, Roy.
Yeah.
So, other than legal interest, how about, say, financial interest? Like, it's a property that you're involved developing.
Then you would be the applicant
Right.
in that sense. So you are the
Within that
subject.
bubble.
Well, you
I think he's
Yeah.
asking if he's working on a project as a contractor and that property's within.
no.
No.
No. What you might face is if you're working on the property as a contractor, that person is likely a source of income to you.
Correct.
So you would disqualify yourself for that reason on that particular application, but that disqualification doesn't extend 500 feet or 1,000 feet.
Okay.
Am I making sense?
Yes.
Okay, good. I don't always. Sure.
So I'm the BAR member,
Uh-huh.
and I'm also a business owner. I have. Sure, sorry. No, that's all right. So, as a incoming BAR member, I have 3 properties, and even though a issue that's coming before it is outside the 500 feet, the issue could impact what I do in my business.
Yeah, if it would have the legal mumbo jumbo is if that issue could have a material financial effect on your business interest, as defined in the regulations of the FPPC, you would have to declare a conflict. If we're using the 500-foot interest in property, once you're beyond 500 feet, it has to be something that affects these items listed on the slide right now. I'm not sure that if it's like a simple sign application, I'm not sure how that's going to affect your market value materially.
Right.
But other types of things, if you're asked to participate in some kind of decision making, even if it's just making recommendations on them.
But if it's a general issue that Michael has, they're changing the sign ordinance, they're redoing things like that, it affects him directly, affects everyone, but it affects everyone equally.
Yeah, there are a couple of exceptions to conflicts, and one of them is called the public generally exception. It's highly technical, so check with me ahead of time. And then remember 2 things. One is, if I'm wrong, it's no defense for you. Yeah, that's just the way it is. There are city council members who have been prosecuted, and embarrassingly for them, have gone all the way to the appellate court to have the appellate courts tell them, yeah, I don't care what you say your city attorney told you, that was illegal, it's still illegal. But if we're talking about changing a code that's going to apply everywhere, or certainly in a certain zone, let's say the TRC, generally those things fit within that public generally exception because it affects a significant enough membership of the public the same as it does you, that figured that's okay. That's how that works. We already went over that because you asked. Fines and penalties, we've already. So FPPC will give you informal advice. Informal advice is every bit as good as your city attorney's advice, which means it does it's not a legal defense. City council member in Pismo Beach once was subject to a recall. and called the FPPC and said, there's this technical action that the city council has to take in order to get the recall, since it had enough signatures, certified to go on the election. Am I allowed to participate? And they said, well, yeah, because your salary as a member of the city council is a governmental salary. That doesn't count. It's not counted as salary for conflict purposes. So yeah, you can participate. So after he participated, they decided, oops, we were wrong. So they only fined him $5,000. They admitted right in their decision that he had called, he had asked, he had told them all the relevant information. He hadn't lied or misled them in any way. They had given him wrong information, so he only got fined $5,000 for voting on that item. Formal advice from the FPPC, which takes some time, so you have to think ahead of time. Formal advice is a shield. So if you write the FPPC and you ask for formal advice, you have to be complete in the information you give them. They will respond. They are required to give you formal advice if you give them all the information. They're supposed to respond within 21 business days, but they can wave a magic wand and give themselves more time. Once they respond, if they tell you you can participate, that's a shield. If someone comes by later, DA, the FPPC itself, and says, no, we think you shouldn't have participated, and you've got that letter, you're good. Even if the formal advice was wrong, you're good. So formal advice is the way to go. You can look up all the prior FPPC decisions, and it's good to look them up in order to decide how to put your letter together, because I help people put letters together from time to time. But you can't rely on them as precedential value like you would a court decision, because the FPPC changes the personnel over time, and they change their interpretations over time, and you can't use somebody else's formal opinion as a shield. You can only use your own. So we mentioned due process, and we mentioned ex parte context. So that's the only other comment I wanted to talk about tonight, because the new members all heard that and heard Aaron discuss an ex parte contact. What the heck is that? An ex parte contact is not illegal. It's not anything improper. So we're not asking Aaron to disclose that he's done something wrong. What it is it's any contact from anybody not at this meeting about something that's on the agenda tonight. The idea is to disclose it and disclose information you've received that isn't in the packet. Because if I'm the applicant and I want you to approve my project, and somebody who's opposed to it has given you information outside of the agenda that's going to form part of your decision against me, and I don't know what it is, I haven't had a fair chance to rebut it, to tell you that that's not true, or there are these other reasons why you should ignore that even if it is true. So it's a due process fairness concept. It's not required that we have the ex parte language on the agenda, but that's been the tradition here for a long time to encourage people to think about it. Again, you're not saying, oh, I've done something wrong. You're just saying, this is the contact I've had. And if you've heard anything factual about it, state it. Doesn't mean you don't vote. Just means you're giving everybody a fair shot at discussing what you've heard right here at the meeting. With that, I'm done yammering, but now's a really good time if anybody has any questions, because I'm here and I'm not costing you any money, just the city. Okay. Yeah, anybody in the audience can ask too. I'm not.
Yeah, if anybody from the BAR, if they want to come up and if you have any questions, or anybody from the public too, it's a good time to do that right now.
Thank you.
Okay, shall we move on to item 2? Public hearings on new development and city projects. Can we hear from staff review on item A?
Good evening, Chair Williams and Planning Commissioners. Welcome. Congratulations on your appointment. My name is Brenda Messer. I'm the Assistant Planner for the City of Solvang. This item that I am presenting tonight is a minor conditional use permit for 1430 Mission Drive.
Brenda, excuse me.
I'm sorry?
I think I have to recuse myself from this one because I may have interest in the property next door.
I don't believe that we have a formal application or complete application for the project next door yet. I don't know if it poses a conflict.
I would step down. I'll tell you why. Because we didn't go over that slide because I wasn't trying to do the whole thing. But with conflict rules and potential sources of income, et cetera, we look prospectively. So if there's a reasonable possibility of something happening within the next 12 months, if it's just theoretical and you don't have an ownership interest in the property, then you don't have a conflict. But if you're reasonably aware that something in the next 12 months is going to happen and this might affect that project, then the safe thing to do is, if it's truly up in the air, then it's not tangible enough. It has to be reasonable. In other words, if I know somebody owes me $500 and they're going to pay me in 10 months, that's tangible, even though it's not going to happen for 10 months.
I'll give you, I had a potential conflict with the Mercantile because I was negotiating perhaps a lease with them back and forth. I just stepped out. I never got the lease, I never did it, but I just left because I could count there was enough people. Why have the conflict? Why have people? I knew it was controversial. I just don't want to go there and get fined $5,000 even though Roy tells me it's okay.
Well, that, and if I tell you it's okay, it's not a defense.
Right.
The safest, yeah, if the potential ownership interest includes anybody but just you and your significant other, you've got to be outside the room. And it's always safer. Yes.
And you still maintain a quorum, so there's that too.
Okay. I believe I was at.
I'm sorry about that. I just wanted him to speak sooner rather than later.
Understood. Again, this is a hearing on the request of the business owner, Cindy Stapp. She owns a piece of the past. It's located at 1430 Mission Drive. Excuse me. Bear with me. I have a little cough tonight. This is a minor conditional use permit application to sell merchandise outside of the business per zoning ordinance section 117A3B3. I'm not going to read every portion of my staff report since you have it. The recommendation is to approve the conditional use permit, adopt the resolution 1902, and approve the CEQA exemption or refer back to staff. The site is located in the TRC. The business itself has been around for roughly 5 years. It was originally built in 1978 as a real estate office, but it has been operating as the piece of the past for several years. What brought this project forward was a complaint was filed against the property for having the merchandise outside, which the applicant has been working with staff trying to get to a resolution, and we believe that we have found the way for her to conduct this business outside. All of the merchandise that is located outside is for outdoor purposes only. There's examples shown in the photographs that are attached to your staff report. Most of these items wouldn't be inside anyways for sale in the retail store. So that's one of the reasons why she's got the outdoor goods. The findings, we have listed that they've been met. I'm not going to go over each of them. They're in your staff report. It is consistent with the general plan. And again, this project is exempt from CEQA. I am here for any questions, as is Ms. Stapp is here for any questions for her. And that concludes my staff report, but I am here for questions.
Okay, is that okay? Did I get up here too fast?
Yes.
You want me to go ahead? Okay. So I'm Cindy Stapp, and I own A Piece of the Past right down the street. I'm just going to tell you a little bit about myself. I moved to the Valley with my parents in 1980. I attended San Ynez Valley High School and graduated there. And off and on over the next few years, I moved back and forth until I married my husband, and we moved to Santa Barbara. We had kids. He said he never wanted to live here because it was just too boring. He was from Santa Barbara. But once we had kids, we moved back here, and we raised all our kids here. They went to Ballard School, and they all graduated from the high school also. Bruce works for Santa Barbara County Fire. That's one of the reasons we landed back here also. And I opened A Piece of the Past in May of 2014. We were empty nesters, and I was looking for adventure. I got it. As my business grows, we have had some success in selling outdoor merchandise. And so that's been something we've done in the past. But I just want to mention also that I have done a commercial through KEYT in Santa Barbara. I had great success. It was very expensive, but it was good for my business. I had about a 25% increase in business over the 3-month period that I ran the commercial. I also use Instagram, Facebook, and Craigslist to drive business to Solvang, and I feel like we pull in some customers that may not necessarily come to the Valley without that advertising. In a struggling economy, we work hard to keep our customers coming back. We have about 50% tourists and 50% local people that shop in our store, and so we're always trying to pull in new things because our stuff's all one of a kind and different. So right now, you'll see if you drive around the Valley, we have a lot of our outdoor merchandise sprinkled throughout the Valley. So I feel like we've made a good impact with it. I feel like we have met all of the specifications required for this minor conditional use permit, and I hope that you all vote for it and pass it for me. Thank you. Do you have any questions for me?
No, thank you, Cindy.
Thank you.
Should we ask the public?
I did leave several letters of support on the dais, but at this time we can bring any public comment.
Is there anybody in the public that'd like to comment on this item? Come here. State your name, please.
My name is Don McFadden. I'm a resident of Solvang. I am also a dealer in the store of A Piece of the Past. We've been antique dealers for many, many years. I've read the resolution, and I'd just like to say that I agree with everything that's in the resolution. I think it's well done, and it should move forward.
Okay, thank you, Don. Anybody else? No more comment. We'll bring it back to the council for discussion.
Well, the general statement, just for new folks, we've got two kinds of CUPs, a minor and a major. Majors always come to us. Minors can be done at a staff level. This, if you looked at the staff report, is a minor conditional use permit. I think staff just brought it to us so that we could go through the gyrations of it. It makes the neighbors feel good and things like that. It didn't have to, though, come to us. So personally, I don't have an issue with it. I know that we allow, it's where they, and you saw it in the report, the hardware store has their outdoor things because that was probably the first one or second one that was done under a CUP. I know that I personally had a shop that we opened that had outdoor things to sell. It was the original picket fences way back 15 years ago. We went through the CUP process and got it also. So we have allowed it. There is a history of it, not only just with the hardware store, but other shops, retail shops that have it. And I think it's designed so that if you have things for outdoor sale, that they're outside where you don't have the space inside and it takes so much. You have plants that are growing or topiaries and things of that nature. That's the reason behind it. Ergo, you see the hardware store. But you will have other folks say, how come the staff's got it outside and we didn't get it outside? Well, they have to go through the process, and it's got to fit in the categories of doing it. We just have to be prepared to say no or yes, just depending on it. So I'm just giving you a general feel. My feeling is it meets the criteria. I'll be voting in favor of it, but everyone does their own thing. But this is our time to discuss and say how we're feeling.
Do we need to know what precipitated the complaint in the first place? The complaint in the first place? Do we know precipitated that?
I don't think we can give the complainant's name at this time, but it was basically, why do they get to have this outdoor merchandise without approval?
Okay.
And hence, they're here for approval.
Yeah, the only thing I noticed about the site was I believe it's like a flag driveway going into, there's 2 residences back there. I thought maybe that was an issue or something.
One of the letters is from.
They'll have to, and this may or may not be.
Okay. One of the letters is from one of the residents behind me.
Okay.
And also one thing, just real quick about what Aaron said. My property is very different than any property in the TRC. I have my own private parking lot, and I have the space that I'm using is all in my private property. I have nothing on the sidewalk or in public property. So if people ask why mine is different and why they can't have what I have, my property is very different, so it's a unique situation.
Is there a time limit on the approval, or is it forever?
A conditional use permit runs with the land, so there is no time limit. If they violate conditions of approval, then there is a revocation possibility. But that is one of the unique qualities of a conditional use permit. Hence, it's a good idea to have a public hearing about granting those, since it is a permanent condition. They do have some expiring provisions if the uses change dramatically, or gets rezoned.
And there is, under our conditions of approval, which we'll need to approve, B9 says that quarterly inspection, the owner shall provide access to the city staff to perform a quarterly inspection of outdoor storage of merchandise to verify compliance with the conditions. Generally, conditions of approval are that. There's some way for the city to come in and make sure that they're doing it, or yank it away. We gave a CUP for timeshares down on Copenhagen Street behind the hotels there that were the 4 units. The city will take every year complaints and see about noise and things like that, and they can take away the Airbnb status of these 4 condominiums or single-family houses that are down there. And that's where the enforcement mechanism comes in on CUPs.
And then you will see and hear about from time to time in other jurisdictions where they do put such language in CUPs that it's only going to be for this period of time, or they'll even say, well, this one's going to be revoked for whatever reasons other than normal. And I don't encourage us to do that here, and the reason is everybody who uses them loses. When they try and enforce them, they lose in court. So it's good political window dressing to put them in, but they're not really enforceable. People don't comply and they create a nuisance, you can revoke CUPs, but you have to follow those types of procedures. We can't put in any arbitrary timelines and have them withstand a challenge. Even people, some cities have tried to say, well, you got to reapply every year, or you got to, it's like, no, it's either a good idea to grant the CUP or it isn't.
As long as you do certain.
Right.
Anybody else? I'm pretty much in favor of this as well. I mean, I've been there several times. And where she wants to put this is not in view from the street at all. You can't see it. You have to pull into the driveway into her parking lot to see it. So I don't see any reason not to approve. Any other
Would you like a motion? I'm okay with,
If
okay.
there's no more comments, if we could have a motion to one way or the other.
Okay, well, I will move, and there's a few things here, but I'll move to adopt Resolution 19-02 and approve the minor conditional use permit subject to the conditions of approval, which are included on Attachment B. And I will also move to accept the categorical exemption under the CEQA guidelines included in Attachment C. So all 3 I would move to approve.
Okay. Do we have a second?
I'll second.
All those in favor?
Aye.
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 4-0. Okay, let's move on to item B. Brenda, if you could.
Little applause. We don't always hear that at the Planning
Well-
Commission, but that's fine. That's nice. Shows
Maybe
true
first
spirit.
off, on item
Thank you,
B,
Justin.
I should ask if anybody has a conflict.
The only
I
ex
do not.
parte
I
I
don't.
have was, I had mentioned earlier that Ben had come to me and I said, go please to city staff. He asked what I thought and I said, you need to just do the process.
Okay, so we can move ahead.
Good. Good evening. Holly Owen, I'm Planning Director. First of all, welcome. It's very reassuring to see the seats all filled and the binders open. And so we're pleased and looking forward to what's going to be, I think, a pretty busy year for the Planning Commission. We have before you tonight a hearing on a request of the property owner, Ben Peterson, for the approval of a new duplex in the DR20 zone district. The applicant is requesting 3 modifications to the regulations in the zoning ordinance for the project, and there's a categorical exemption from CEQA for this project also. You have some recommendations to make the required findings for approval and to adopt the resolution and approve the project, subject to the conditions of approval in Attachment B, accept the CEQA determination or refer this back to staff if you feel that that is necessary and required. A little bit about the site information. I think in your staff report you have some photos as an attachment, so you can get a visual of where the property is located. We always encourage staff. It's always useful to drive by projects, and we would certainly encourage Planning Commission to, at their convenience, do a visual survey yourself when you're looking at projects. One of the reasons I bring this up is that this is one of the smallest residential lots in Solvang. It is zoned for a duplex. It's the request is for a 2-story duplex on Elm Avenue. This is actually a typo. It's bigger than 1481 in the project description, and that change should have been made at our final edits. But it is small. It's surrounded by smaller single-family residential units. And as the project is new construction and over 300 square feet in size, per our zoning ordinance and our practice, a development plan is required. The development plans do come to Planning Commission. We have made changes to the zoning ordinance where the planning director can approve projects without a Planning Commission hearing in the DR20. But given the number of modifications that this project was requesting, we felt that this was an opportunity for Planning Commission to weigh in on this, to review and possibly grant those modifications. And then there was another modification that was requested in terms of density from staff. It was presented at the Development Review Committee on October 12th, 2018. Just to give you a little background of what the Development Review Committee is, it's an in-house review. It's really a favor to be done for the applicant, an opportunity for the applicant to get feedback, not only from planning staff, but public works staff. Santa Barbara County Fire is invited, and any other agencies or stakeholders that might feel they need to weigh in on that project. It's usually held in the middle of the day, and so that gives the applicant an opportunity to receive comments and get questions answered, and then perhaps make some changes to the project as may be fit. As I mentioned, it is in the design residential district. They have you have information about the modification request that the applicant is making. The minor modifications to the zoning ordinance is allowed by the Planning Commission under development plans and by the Planning Director under another part of the zoning ordinance. So what is in front of you is the minor modifications to the setbacks. Now, ordinarily, a project does not come with more than one or maybe two modifications that are requested. But due to the constraints of this lot, given the fact that it is one of the smallest lots in the city, we felt that this was a justification for the granting of the modifications. And the same went with the density requirement too, or what they needed to have this work to create livable space in such a small lot. Required them to go just a little bit above the required the limitation on the density that was outlined in the DR20. That's not. Am I done? No. So that's in a nutshell, sort of what the project entailed in terms of what they were asking. Staff was in approval of this, and I think one of the biggest considerations for us as staff in terms of general plan consistency is that we have a housing element that really compels us to look for ways to support a variety of housing and frankly a greater density of housing. But we're going to see that in the present, but especially in the future as the legislature weighs in and makes density a higher and higher priority. We've decided as a community that we don't want to grow. We don't want annexation. So what we're going to get as a trade-off is greater density. So we might as well start evaluating that kind of product and holding them to a higher standard and allowing them where we can. So that, just in a summary, that's where staff comes as a conclusion for this project. And I am available for questions. I know the applicant is here. I did want to say that in the conditions of approval, we called it Elm Street. It should be Elm Avenue. And they have gone to the BAR for their final approval. So they do not need to. B1 under project-specific conditions can be eliminated since they already went to the Board of Architectural Review and they received approval there. The applicants are here tonight to answer any particular questions about the project, and this concludes my staff report. Thank you.
Does anybody want to speak from the audience on this? Ben? Yeah. Sure.
Yes. Chairman Williams and Commission, congratulations. Mr. Williams, Mr. Rodriguez, probably also Mr. Peterson, congratulations for giving it up. But my name is David Goldstein. I'm the architect and agent for the project. And we've been working on this for a couple years, trying to get it to the point it is now that we're presenting it to you. There are a couple things. I think Ms. Owens did a great job describing what's been done, and we're trying to. I think that the project started out as a question about, I'd like to upgrade the one unit that's on the property. Mr. Peterson wanted to upgrade the unit that's on the property, and we looked at the unit, and it needed a lot of work. And wanted to possibly take the property to a higher and better use and put in a duplex, put in some nice units in the duplex for 2 families, 2 people to be able to live in downtown Solvang and enjoy the living space there. So that's why we took advantage. We did take advantage of the minor modifications that are allowed in the code, and we packed the project on the site. And I think if you looked at the plot plan, some of the drawings that presented to you, you'll see that there's still plenty of living space on the ground for the occupants. There's an outdoor balcony on the second floor for each apartment, and plenty of space for that. There's the required parking is provided on site, and we are taking advantage of lesser side yards and front yard, but I think we're still providing a very livable project, and something that Mr. Peterson and the city can be proud of. I would like to address a couple of the conditions on the project, and that is the condition B2 also requires us to be reviewed by the Board of Architectural Review, which we've already done. This is regards to lighting, and we specified, and you'll see on the drawings that we presented, we specified the actual fixture that will be used for the project. Also on condition C3, that ask us to install an 1.5-inch water service and a 1-inch meter on Elm Avenue. We have a note on the drawings, and the staff has looked at the note, and I thought assured us that it was okay, that we will confirm the need for a 1-inch meter by an engineer. An engineer will confirm that, whether we need a 1-inch meter in fact, or possibly be able to use a 3/4 inch or a 5/8 inch meter. You probably know the cost between those is significant, and we want to, of course, have the water capacity that we need, both for the 2 domestic units and the fire sprinkler systems, but we will confirm that as we're going through the engineering for the project, what size meter we need.
Go ahead, Ray. You go ahead.
And out loud. Have we discussed this with engineering staff?
The current proposal of theirs to come with an engineering recommendation outside of staff.
The condition that's listed currently is the most current condition from Public Works staff after seeing the final plans.
So in other words, what is in the conditions of approval at this time is what Public Works is requiring for now. Now that said, I'm sure that Matt Vanderlinden's staff would be happy to meet and discuss this particular conditions with you again. But at this time, I don't feel like since they're not here to address it either way.
I'm not saying it won't be a 1-inch meter, but I'm saying that when we're designing the building and we have a plumbing engineer and a mechanical engineer doing the work on it, that they will verify and calculate what size meter we would actually need.
I'm sure the staff would accept some sort of advice from that, but whether or not they would, that ultimately it's their decision.
Okay, I thought it was our understanding that would be the case, but we'll see what happens when.
Did you have any other conditions you wanted to comment
about?
Yeah.
What were we on? B4 or B3? B3. No.
No, we were on
C3.
C3.
C3. So C4 also, I think there's a little misunderstanding. The existing sewer does go out to Elm Avenue. It doesn't go through the neighboring property to First Street. So we're going to hook into that existing sewer lateral that we have in Elm Avenue. I mean, that's shown on the drawings, and I'm pretty sure Mr. Peterson has discussed this with the Public Works Department and verified that that's where the sewer goes.
Go ahead.
Excuse me. The Public Works staff, engineering staff, they were the last people to give us their most current conditions for this staff report. We can certainly bring these items back to them for discussion. I'm not sure how we revise those conditions to be approved at a later date with different verbiage.
Why don't we make sure we hit all the conditions, and then I'll talk about it.
Okay, the sewer actually, sewer line from the existing house out to Elm Avenue has been videoed and photographed, and there's a little problem where it connects up to the sewer main in the street. But, I mean, I'm pretty sure the city knows where the sewer goes. That's it as far as conditions. Yeah. Any questions?
Yeah, for the fire sprinkler company, I think that's what you're getting at. You're going to get an engineering recommendation from them to tell you the meter size or the line size.
No, we'll
going
have
into the building.
a plumbing engineer, mechanical engineer go through it, and engineer the plumbing requirements for the 2 units and the fire sprinkler system.
Okay, in total.
And see what size meter would handle it.
Okay.
Yeah. The whoever does the fire sprinkler system will chime in that too.
Right.
But our engineer will look at the domestic use also. Make sure we have enough water for the whole property.
That sounds appropriate. It says there's check valves on the sewers there. Is that because of the manholes? You have manholes downstream, or you don't have one downstream?
No, I think that the backflows are just a requirement for new development.
Okay.
Yeah. That was required by the city.
Just curious.
I have a question on item B2, on the aesthetics. You talked about the lighting. It wasn't clear, has the BAR already approved that? Or
I
is
don't
that
have the
to be
exact
approved?
date of that BAR approval, but they had originally gone for a concept review, but approved all of it as a final approval at that meeting.
Yeah, that was last March.
The light fixture is on your drawings that were submitted with this.
I saw
Yeah,
that.
Yeah.
So those 2 items
They
really
can be
don't
struck
apply
from
because they've
the
already been
conditions, yes.
approved. Okay, I just wanted to make that clear for
When
the-
I put those in, I was unaware that it was a final BAR that occurred when they went for review, but that indeed was the case. So planning staff is in support of the striking of those 2, B1 and 2.
March 8th, you had the phone BAR.
March 8th, yeah. I saw that in here somewhere.
March 8th, okay. Yes, 2018, right.
Yeah, it's 2018.
Right. Roy, were you going to address
Sure.
planning conditions or public works?
I make a deal with staff members everywhere I work where if they don't practice law, I won't do planning, or I won't do engineering, or I won't try and manage the city, those types of things. So I remain reluctant to change any conditions from engineering because I'm not an engineer. Likewise, engineering is not generally in the purview of the planning commission. But the conditions are in front of you, so you have two choices. One would be to postpone a decision tonight so that engineering could comment on or come back. I don't know if that's acceptable. The only thing I can think of doing as far as C3 and C4 goes that would be consistent with that philosophy of me not doing engineering, and I can make simple math mistakes at meetings, so I really shouldn't do that, would be to change the conditions just slightly. For instance, item C3 could read, abandon the existing water service along the, install new 1.5 inch water service and 1 inch meter, and then in parens before the comma, unless a smaller size is approved by the city engineer. And then under C4, instead of striking abandon the property's existing sewer lateral, because I don't know if there's one under there or not, would just be to say if required by the city engineer. That way the city engineer could make a determination if there's one that needs to be abandoned or not.
Thank you.
But I just personally don't recommend striking them.
No. And, you know, the comment I would have is if we look at things like D3 on the next page, way down, it's kind of open-ended, right? Prior to issuance of land use clearance, you submit grading and have it all approved. It's kind of the same thing. They can't do this unless it gets approved by city engineer on the sewer lateral and the meter meets proper. And I think that's fair to the applicant, fair to the city, protects the city. And a lot of times it is general like that on conditions. Yeah.
And sometimes it's general when you feel like the project is ready to go. We have the conditions. We haven't necessarily spent a lot of time talking to the applicant about the final conditions, but they've been involved in the conversation from the beginning at Development Review Committee, for instance, and in other conversations that we're always available as staff to discuss particulars with applicants or concerns. So I appreciate Roy's suggestions. I think that gives us the flexibility to go forward. You, as Planning Commission, could also choose to continue the item.
Any other comments from the public? Okay, we'll bring it back to the council for discussion. Anybody have any comments, thoughts, suggestions?
I mean, it's easy for me to start, and I'm not trying to run the meeting. Again, we're dealing primarily the conditions of approval separate, that we can make these modifications for if they were typos or they didn't, the staff's going to work it out and we can put that wording in. We're granting, it's a conditional use permit, basically a modification is what it is, that staff under 10%, we allow staff to do, just like that minor conditional use permit on the prior one. I think staff brought it to us so we could go through it because it is a dense, and they're asking for the side yard and the front yard, and the square footage of the lot isn't large enough. But both of the side and the front are under the 10% threshold that staff could determine on their own, and does many times. And it's under 10% on the lot modification, a little bit less. I think we all know that neighborhood fairly well. We see the pictures next door. It's got that 2-story fourplex and then a house attached to it. The backside, and I'm just saying without embarrassing anybody on the record, that hopefully that backside on First Street will get as cleaned up and nice as what Ben Peterson is wanting to do on Elm Street. And maybe this sparks a little bit of a cleanup of that area, because that street is a lot of little jumbled things that have been added on to. I don't even know who owns it, so I'm not picking on anyone. I think it's a pretty building. It's, I think, 2 garages, single bedroom in each. I think the house probably has 2 bedrooms right now and a bath or 2. I don't know. So it isn't in density, but yet it allows 2 families to live there, or 2 couples to live there, if you will, close to town, walking, workforce housing, and all the stuff that we want. So personally, again, I don't have any problems with granting the exceptions and the conditional uses. with striking the aesthetics number 1, B1, and B2 out, have they been already handled, and then Mr. Hanley's suggestion on the other two, on the sewer and on the water.
Anybody else?
I think what he said, I agree, and I think what staff has already done is pretty expedient. And I think whatever helps push the project along, I don't want to stall them any further that's necessary. So I think what you said is pretty good, so I'm okay with that as well.
I will say too, just from staff's perspective, we have supported this project from the very beginning. We've mentioned that to the applicant more than once, that in many ways it meets the needs for some of our more diverse housing. It is in a area that's walkable.
And aren't we trying to deal with the accessory dwelling units, like that impending thing? This is kind of help with that.
Yeah,
a little
that's
bit?
actually a really good comment, because there's the most recent legal changes that are relevant to your evaluating the policies included, and also what's down the pike. So, for instance, if the applicant had wanted to just build one single-family residence, they could have added an accessory dwelling unit, whether we wanted to or not, and we wouldn't have had as much control over how the product looks and how it fits. So you're gaining an advantage by cooperating in this way with the applicant and reaching a good conclusion. The other thing is that where state law is going, and we'll find this in the future, is they do not want cities to use these rules as impediments to density and impediments to development of mixed types of housing. Too many cities have approached the changes in zoning laws over the last few decades as, okay, fine, we'll adopt something that technically complies with the code, but we're going to put so many rules in there that nobody can really do it. And what the state wants us to do is encourage this type of development in one way or another, instead of just using our codes as a way of going, nope, swing and a miss. They want staff and commissions and councils to think more creatively about how to comply, but encourage instead of just say no.
Well said. Thank you. That's exactly right. I think we want to get to a point where we can approve projects like this, and if it takes modifications, or we're not financiers, we can't make it pencil out if it just won't pencil out, and that's for on the private sector to handle. But we do our best when presented with projects like this to look at what we're required to do, to look at where our goals are going in terms of providing a diversity of housing, and we try to make it work, and this is a good example of this.
Okay, anybody else? From my perspective, oh, I'm sorry.
No, go ahead.
No, go ahead. Okay, from my perspective, what most of the points I was going to make have already been covered. I think this is a good project. I think it's going to add to the neighborhood, and it also will get us essentially one more living unit on the same footprint. And the modifications that are being asked are pretty minor and within the technical leeway of the zoning ordinance. So I don't see any reason not to approve this, and I would not like to continue it based on the problems with C3 and C4. If there's some way that we can either word this or let it be known that this can be handled within the planning department and not have to come back to the commission.
Yeah, I agree. If we can word this to do what we were talking about, so it runs with you concurrent, then yeah, I think it'd be a great project. Really add to the street, Elm, and the area in general.
I agree as well.
Okay, if there's no more discussion, would somebody like to make a motion to?
Can I just make a general comment on meters? And this,
Sure. Go ahead.
the reason, because we were chatting a little bit about the size, a 1-inch meter it's $189 a month, whether you use a drop of water or not. A 3/4 inch meter, I think, drops down to $135, and I think a 5/8 is down to like $87. So it's a big difference on a monthly bill. And so if you're required a 1 inch, it's $190 whether you turn a spigot on or whether you're on vacation or the thing sits vacant, which is amazing. And that's a whole different issue that obviously the city's dealing with. But that's probably, it's a financial push, it's not a need push. So that's probably why it came up. I'm just throwing that out.
Well, yeah, I mean, it's also concurrent with fire sprinklers being with every new. It bumped up everyone's meter if you're doing new development.
That's right.
Whether it is a remodel and you're adding, you need to add the fire sprinklers, then you're ripping that old one out.
It's part
putting
of the
a bigger
building
one in.
code
It's
now.
part of the
That's right.
whole thing now.
Yeah, every time.
I know, it's gotten crazy. Well, I'll make a motion if that's what you're looking for. I don't know where I'm at with the recommendation. Adopt resolution 19-03, attachment A, and approve the project subject to conditions of approval as attachment B, and accept the category exemptions pursuant to, is it attachment C, with the modifications that the city attorney has recommended on
C3 and 4.
elimination of B1 and 2, and also C3 and 4. Did I do that right?
And how about the CEQA? Do we have to do that separately?
Oh, I'm sorry. Did I do CEQA?
Yes, you said, yeah.
It was
you
a
said
mouthful,
the
so I'm not sure.
modifications.
If I didn't, I do. I include CEQA.
Okay, is there a second?
A second.
Okay, it's been made and seconded. All those in favor?
Aye.
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 Aye. Pass 5-0.
Thank you.
Thank you. Thank you, Ben.
Back to the agenda. Are there any other discussion items that we need to go over tonight? Planning Commissioner comments?
The only, it seemed you guys understood it all. Flows pretty easily, pretty good in it.
No, it's a welcome mix. I very much appreciate what you're all bringing individually and then collectively to the decision making processes here. It is a technical committee compared to the BAR. They're very different committees. I'm glad that they are what they are at this time. I'm happy also that you will be attending Planning Commissioners Academy. Ryan Cuff will be going, I think, still. Is that correct?
Yes.
Justin, you'll be attending, so we hope by the next meeting you'll have a briefing for us, teach us some of the hot topics, and give us your impressions of your trip down there, too. So that would be welcome. I think we will be having an accessory dwelling ordinance coming in the next couple of months. It's been a long-running discussion in this city and in every other city in California. A lot of jurisdictions are still working their way through an ordinance because the laws changed, and then they changed again the next year. So it's kind of playing. And they'll probably change next year. So at this point, we are processing ADUs. If anybody wants to come and see me about a more one-on-one conversation on that, I'm happy to have that. So, and Brenda really is our ADU expert. So
That means this book is going to be getting a lot bigger then, right?
books always get bigger. They just don't get smaller.
One comment on the last, I went to one of these, the last one I was at, and it was in San Diego years ago, and you go into these big meetings, and you don't think it's going to have anything to do with anything that you're care about in Solvang, and we were kind of bored. I don't even know, maybe it was Jack and I. There was a couple of us that went on, maybe it was even before that, and it had to do with massage parlors. And we thought, well, this will be, what in the world? Okay, let's just sit in this thing of massage. Then we found out as all these cities in Southern California were realizing there were strips of 20 and 30 massage parlors opening up, all owned by the same syndicate, if you will, of all this slavery, all this stuff that was going on. We were just, our jaws were up, but we came back, went to our staff and said, we got to get a hold on this right away, because if you didn't pass something quick, once they're in and they got a license and they can be in a Tier C zone, or they can be they're here, and you're not going to get them out. It's kind of like then they're grandfathered in because they got in, and we did that. So you'll go into these things thinking it has nothing to do with the city of Solvang, a little bit, but they're big issues that are out there with the medical marijuana and all this stuff and ADUs, and who would thought massage parlors, you know? But anyway, so you have a good time. You'll learn
There are
some
big
stuff.
towns and small towns. It's not all made up of LA, San Diego folks, and so you'll find yourself sitting next to people who, you know, are from the Inland Empire or, you know, up north, and they all bring a different perspective, and yet some of them are struggling with the same challenges. So it's always good.
You guys gonna adjourn?
We do have one more. Yes,
Okay.
you should probably adjourn. Yes.
I think we're adjourned if nobody has more comments.